Before this hearing even begins, you need to understand what's at stake. We're not just talking about a routine bond decision. We've got a man on lifetime probation out of Michigan, facing an armed robbery background, now charged in Texas with aggravated assault with a deadly weapon, allegedly involving children. Add in multiple bond violations, GPS monitor issues, and a potential interstate compact hold, and suddenly, this isn't just about paperwork. It's about public safety versus second chances. The judge makes it crystal clear from the start. This isn't about guilt or innocence. It's about identity and whether Mr. Thurman should walk free while all of this plays out. And here's where it gets intense. The prosecution paints a picture of escalating violence, while the defendant insists he's been working, staying clean, showing up to court, even turning himself in voluntarily. So what do we believe? Is this a man trapped in a cycle of charges and technical violations? Or is this exactly the kind of pattern that makes a judge nervous about public safety? Pay close attention to how the judge frames the issue. Not, did you do it, but can I risk letting you out? That distinction is everything in bond hearings, because bond isn't about punishment, it's about risk. And in this courtroom, risk is about to be debated in real time. Let's get into it.
Stop.
Like, oh,
You do not tell me how to do my job.
You be like, oh, you grab my arm too tight.
Guys, relax.
I'm too tight.
Relax.
Oh, I said, grab me. Look how you grabbing me up.
Now, you are Mr. Thurman, correct?
Sir.
Okay, Mr. Thurman, I've never met you before. I don't know you. All I know is that you have picked up a case from out of state. And well, give me a second, and I will let you. But, here, so we're not disputing the underlying charge. We're not fighting it. None of that matters. What we really here are all about is identity, right? Are you this person? If so, how do we get you back to the jurisdiction that you're wanted from? So here it says that you are wanted from Michigan, Washtenaw, Michigan.
Washtenaw County, yes.
Yeah, Washtenaw County. And it says here that you're wanted out of there for armed robbery. So I know that you're going to tell me it's little bunnies jumping in the woods. It's not that big of a deal, yada, yada, yada. But my primary concern is public safety. We have enough death, dismemberment, and hysteria in Harris County as it is. And I don't want any more blood on my hands. You know what I mean?
Yes, sir.
Shh. So your lawyer is asking me to set you a bond, and I don't know, because if you're a public danger, I'm going to have a hard time doing it. Right?
Understandable, Your Honor.
So, oh, Miss Chisholm's not even here.
She just jumped off because she was just up there.
May I speak, Your Honor?
Your lawyer's not here.
Okay.
So until your lawyer gets back, I'm not going to let you go. I'm going to bring you back out, but your lawyer's not here. I can't talk to you without your lawyer here. So I'll bring you back out here as soon as she gets back, and then we'll go right through the rigmarole again. Okay? Sorry. I didn't even realize she's not here. Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
Okay, let's pause right here, because lifetime probation is not something you hear every day. That's serious. Lifetime probation typically follows extremely severe offenses, and it means the court maintains supervision indefinitely. That alone raises the stakes dramatically. Now, add to that the prosecutor mentioning prior murder charges, even if dismissed, plus aggravated robbery. Even though the defendant pushes back on the wording, the mere presence of those allegations in the record creates a psychological weight in a bond hearing. Judges don't ignore patterns. Here's the key legal takeaway. In bond determinations, the judge considers criminal history, prior compliance with court orders, and danger to the community. So when you hear lifetime probation, the judge immediately thinks long-term supervision for a serious offense. That tilts the scale toward caution. But here's the question for you. Should someone be permanently defined by their past, especially if they've already served their time? Or does the pattern matter more than the timeline?
Yes.
Whoa.
So that Kate, well, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was
twice.
about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to.
This is the turning point. The prosecutor just introduced the most damaging piece of information so far, allegations that a gun was pointed at a complaining witness in their children, along with threats to kill everyone in the home. Legally, this is massive. When children are allegedly involved, judges shift into maximum caution mode. Public safety becomes the dominant factor. And notice how the prosecutor layers it. GPS violations, curfew issues, prior armed robbery, and now a new alleged violent incident. It's building a narrative of escalation. But here's something important. These are allegations, not convictions. In a bond hearing, the judge doesn't need proof beyond a reasonable doubt. They only need enough concern to justify detention. So now ask yourself, if you were on that bench and you heard gun, children, and lifetime probation in the same breath, would you feel comfortable setting bond?
A bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he is ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. After we talking about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though.
I understand
that.
that.
That's why he overlooked. He said, okay, it's fine. He said it was fine.
Quick question, is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
this month.
heard, okay, and then so there's not been a hearing on that yet, right?
No, but that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea deal.
What are you on probation for?
The armed robbery conspiracy committing armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I would say, so I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I'm been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew
Yes.
and you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time at us. I forgot what time it had as. But I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, you've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they're already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. Obviously, I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent.
This is where things get complicated. The defense makes a strong argument. He showed up to court. He flew back to Michigan. He turned himself in, knowing he'd be arrested. That directly challenges the idea that he's a flight risk. And legally, that's significant. Courts do consider voluntary surrender in consistent appearances as indicators of reliability. If someone keeps showing up, it weakens the prosecution's argument that they'll run. But here's the tension. Appearing in court doesn't automatically erase concerns about public safety. You can be compliant with court dates and still pose a risk if new violent allegations keep surfacing. This is the clash we're watching unfold. Compliance versus pattern. Personal responsibility versus alleged recurring violence. Redemption versus risk.
Recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Okay. Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy 2021. Probation transferred to Texas 3/2021. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed at a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I would say something, Your Honor. That's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like somehow, sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. You know, Mr. Thurman, you
When a judge says you scare me, that's not casual language. That's emotional transparency. And while judges strive to be neutral, bond hearings are inherently predictive. The judge is being honest. Based on the totality of the record, they're uneasy. Notice the judge's reasoning. It's not just this case, it's the accumulation, armed robbery history, aggravated assault allegations, repeated bond violations, GPS monitor issues. The judge even uses a metaphor. You pick up another charge like a cold. That tells you how they're viewing the pattern. Now here's the legal reality. Bond isn't about rewarding good behavior, it's about preventing future harm. And the judge explicitly says they don't want more blood on their hands. That phrase shows how high the emotional stakes are in public safety decisions. But is fear enough? Or should objective facts override that gut reaction?
Speak on it on pretty say much, but it's a lot more to what you're just reading on that police report. You know, it's always going to be video cameras and house ring cameras, body footage. It's going to be a lot more other things that you're not going to be able to read off a police report, which is understandable.
just too much blood, Mr. Thurman. I'm sorry. I can't set you a bond. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really. I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, Sean. And y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year, I've been out, and they just not issue a warrant for me just now, recently. And I come to turn myself in, and I'm a threat to society. And people, you fear me for what? From turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You do not tell me how to do my job.
You can let go of me. You grab my arm too tight.
Guys, relax, relax.
I'm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him, I should let me go a little bit, sir. That's all I said.
Open the door.
Escalation right there, that moment of physical tension with deputies does not help the defense. Even if frustration is understandable, optics matter, and in court, composure is everything. From the judge's perspective, this reinforces the concern about volatility. Judges are constantly evaluating demeanor. Calm under pressure signals stability. Emotional outbursts, even minor ones, can confirm existing fears. However, let's be fair. Imagine hearing you're being denied bond, being told you're scary, and feeling like your year of compliance doesn't matter. Frustration is human. But here's the cold legal truth. Bond hearings are about perception as much as procedure, and perception in that moment likely solidified the judge's decision. Would you have reacted differently in that situation?
Hey, what do you make somebody cuss you out or anything? You said I'm a hard type, you just love me. You know what I'm saying?
So he already waived, so if he
He did.
holds it, then it.
Just, yeah, I
Yeah,
can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated, I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much.
It looked like there was.
Even, and I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even,
No, and I was curious because when she brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they going to come get him?
Oh, no, they're gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not?
No.
He said he did.
No, he's not made bond on those cases. He's
He's been
basically,
in jail for a year?
No.
He may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there and I
There you go.
didn't have the heart to tell him right now that the 14 days is not gonna apply.
Yeah.
Because
I gotta do that.
Well,
really.
I would
I
imagine-
it's
will.
just-
I'll let him know.
I would imagine it's gonna get resolved, because it's one of those, it's a bizarre, so we revoked, Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events, because the only thing the court sees is that they revoked
So-
on the probation, which was caused by.
Please let him
race.
know that the 14 days hasn't kicked in and it will not.
It will not kick in.
Resolves.
Right,
And either he resolves the cases.
So which
Okay.
one does he need to resolve first in
Because-
order for,
well, for the felon possession of the weapon, hold on, I don't want to.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been separate jury trial at least
four
Really?
times?
4 times.
Yeah.
1, 2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6th, 2025. But he's held on 55,000 bond for the ag assault and 55,000 for the felon possession. So he has to come up with 110,000 for.
Now, this is an interesting procedural twist. Even if the judge had granted bond in this hearing, it wouldn't have resulted in release. There are already $110,000 in outstanding bonds on other cases. That's crucial. Sometimes in court, arguments become symbolic. The defense is fighting for bond here, but practically speaking, the defendant isn't walking out unless multiple financial and legal barriers are cleared. And notice the chain reaction discussed. Michigan revokes probation because of Texas charges. Texas revokes bond because of probation issues. Interstate cases create these cascading consequences. This highlights something many viewers don't realize. The justice system is interconnected. One charge in one state can trigger holds and revocations elsewhere. So the question becomes, is this system protecting the public efficiently, or does it trap defendants in a cycle that's nearly impossible to escape?
Wait a second. So
So it doesn't matter what you did today.
can't,
Right.
even if I gave him a bond today, he would still have to make those bonds.
110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
explain
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan
Well,
revokes.
I should
Oh,
say
no,
only.
it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay,
It's remand to custody, violation report, but that's not a revocation. Yeah, because,
it's a violation report from Michigan?
no, for me, so remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of.
Let's break
Next
this
time
down
it's
professionally.
January 6th,
The
2025.
judge denied bond,
but
citing
he's
public
held
safety
on
concerns
55,000
tied
bond
to
for
a
the
history of
assault and
armed
50,000
robbery,
55,000
lifetime
for the felony.
probation
So he has to
status,
come up with
alleged
110,000
aggravated
for-
assault involving a firearm
so-
and children, and
So it doesn't matter what
repeated
you did
bond
today.
condition violations.
Can't.
Even without
Right.
those
Even if I
violations, the
gave
judge
him a bond
admitted
today,
they would still be
he would still have
hesitant.
to make those
The
bonds.
central issue
110,000.
wasn't
So my
guilt,
question
it
now
was
is, when did
risk.
that warrant for the
Legally,
felonies
the ruling
pick?
aligns
Because
with
he's
bond
saying he's been out
standards.
for a year
Protect
ever
the
since this
community,
ag assault got
ensure
picked
court
up.
appearance, and
I
evaluate
show a remand
past
defendant
compliance.
custody on
Whether you
November
agree
18th,
with
but I
it or
don't know what
not,
the
the
previous.
decision reflects how courts weigh
So the only reason why
patterns
his
over
felony bonds
promises.
got
This
revoked
case
was because
underscores
Michigan
a broader
revokes.
issue
Oh, no,
in the
it
justice system.
doesn't, but
How
we
much
don't
weight
know
should
that for
past
sure.
conduct
Because
carry
it doesn't,
when
there's no
someone
notes that
claims they've
reflect why
changed?
they revoked
And
the
at
bond.
what
It just
point
says
does caution
court directive
override
remand defendant to
rehabilitation?
custody.
Now
Let me
we
see
want
if
to
they
hear
give
from
an
you.
explanation. Hold
Was
on.
the judge
Okay.
right to prioritize
It's
public
remand
safety?
custody,
Or should the
violation
defendant's
report, but that's not a
voluntary
revocation.
surrender
Yeah,
and
because-
year out of custody
It's a violation
have
report
carried
from
more
Michigan?
weight?
No, for me.
If you
So,
found this case as
remember
shocking
when I
as we
said
did,
the newest
make sure to
violation
hit
was
that
on
like
November
button,
1st
share your
for all
thoughts in
curfew
the comments,
violations?
and don't forget to subscribe
from
for
here?
more
Technically, that could be the
jaw-dropping
reason why they
courtroom
revoked
breakdowns.
instead of